Back in February, the Supreme Court struck down Trump's tariffs 6-3, and within hours, new tariffs were already back immediately. You think a loss like that would slow someone down, but it didn't, not even a little. Hey, I'm Linda. If you're new here, subscribe. I'll be putting out more of this. As I promised in my last video, I'm finally getting to the Supreme Court striking down Trump's tariffs. And here's the thing. Just because it's a Supreme Court doesn't mean that this changed anything as much as some people thought it did. I actually want to show you who made this call and what's still standing no matter what. So today I'm walking you through it, what the court actually ruled, why tariffs equal taxes, that whole framing, I'm challenging that. Who's actually behind the ruling, who brought the lawsuit in the first place, and what tools are still on the table, including one with a deadline that's literally 2 days away. And yes, what's all over the news right now are the 50% tariffs from Trump on Canada this week. That's freaking everybody out. And that's a whole different law, a different story. I'll get to that one later. But let's get into this one. Here's what actually happened. So the Supreme Court ruled the president does not have powers to impose tariffs under a law called the IEEPA, the International Emergency Economic Powers Act. Trump used it for two things: reciprocal tariffs bilaterally with other nations, and tariffs tied to fentanyl trafficking with China, Mexico, and Canada. Sounds reasonable to me, particularly to shut down the fentanyl trafficking. And here's the court's reasoning. That law allows the president to regulate trade during an emergency, but it doesn't let him tax it, because a tariff legally counts as a tax, and taxing power belongs to Congress. That's how they struck it down. Now, the IEEPA has been on the book for 50 years, since 1977, used by presidents for sanctions and asset freezes, and has never been read as a tariff law until Trump. Now, here's the part I want to flag and challenge. The Supreme Court says a tariff is a tax, and right now, mechanically, it feels that way. But a lot of people take that to mean a tariff only ever does one thing: to take money away from you. But if you study history and you look at it thoroughly, that's not how Hamilton, Henry Carey, McKinley saw it. And it's not actually how it functioned during our history, during the era of tariffs. Now, Bob Ingram made the case for that in my interview with him on the tariff lie. You can go watch it if you want the receipts. But for now, we'll just focus on this topic. Now, here's the part I find really interesting. Who actually brought the lawsuit? It wasn't the left, it was a libertarian law firm, the Liberty Justice Center, representing a toy company and a wine importer. Now, this came from inside the free market right. And the justices who leaned the hardest to shut these tariffs down have their own history. Like John Roberts, who spent his career as a corporate lawyer, and the U.S. Chamber of Commerce campaigned for his confirmation. Barbara Boyd over at Promethean Action have talked about this. And since then, John Roberts has sided with the Chamber's position in 2 out of every 3 cases they weighed in on. That's the data. And it's not just the court, and it's not just one side. Yesterday, Senator Ron Wyden, Democrat from Oregon, introduced a bill to strip the president's tariff power entirely. Not tweak it, strip it. So next time when someone tells you, oh, the Supreme Court ruled, remember, a court is made up of people with histories. And this one has a track record worth knowing before you treat any single ruling as a neutral final word. It really goes for anything. And this fight isn't over. But here's what isn't made clear to you. The president still has tariff power under at least 3 other laws. None of them touched by this ruling. First, Section 232, which are national security tariffs, which are steel, aluminum, and autos. Section 301, unfair trade practices aimed at dozens of countries, and I've actually touched upon this in my previous video on how the Washington Post defends modern slavery. And Section 122, and this one's called abridged tariff for a reason. It's a temporary law capped at 15% and legally limited to 150 days. It's not meant to be permanent. It's meant to hold the line while the more durable tools, 232 and 301, gets built out more. And even this one's not as sweeping as you may think. It exempts a lot: pharmaceuticals, semiconductors, critical minerals like cobalt and lithium, certain energy products, and the idea is never tax everything. It was tax enough to hold the line while we carve out what the country still needs to import. So now Jamieson Greer, our U.S. trade representative, said it plainly right after. Over the years, Congress has delegated enormous tariff-setting authority to the president. So even though the Supreme Court struck down tariffs under one authority, tariffs under other tools remain in place, and the administration can keep running investigation under those tools to maintain continuity in trade policy. So what does that mean? Unlike the IEEPA, Section 301 and 232 require a real process, an investigation, evidence, public comment, before tariffs can be imposed. Slower than an emergency declaration, but it gets to the same place. So that 150-day clock on Section 122 runs out tomorrow, Friday, July 24th. Congress hasn't extended it, and the president can't extend it on his own. So by the time you're watching this, we might already know, did it lapse or did it get replaced by something that actually lasts? 3 separate laws ready to go if one gets struck down. And honestly, that's the real story here. I don't think the Trump administration is losing this battle here, no matter what the headlines make it sound to be the day of the ruling. Now, this whole talk of tariffs goes deeper than just tariffs. I know it's been a couple of weeks since I put something out, and I'm aiming to get back to put out content weekly. So stick with me. My next video, I'm diving deeper into the stir that JD Vance is making, that the Republican Party is moving from Milton Friedman to Alexander Hamilton. Now that's a huge statement, and it's already pissing so many people off, and it's already pissing the right kinds of people off. And once you get what he means, this whole tariff fight is going to make a lot more sense, I promise. So if this was useful, hit subscribe. I'm doing a lot more of these. If you want to watch the full case on tariffs, go watch The Tariff Lie with Bob Ingram. Links below. For now, keep an eye on that July 4th deadline. Keep watching this space. Thanks for watching. Stay tuned, stay in the fight, and keep in mind for a very important next deadline, which is this November, and to turn out the Republican vote. This is from someone who was a lifelong Democrat from San Francisco before Donald Trump. God bless. We can all change.